Hello, this is Robert Mansour, and we're going to spend a few minutes talking about the form available on my website, which is essentially a checklist of things to keep in mind after somebody passes away. Whether they died with estate planning documents in place or not, I'm just going to make a few observations and a few things to keep in mind. So, if you found this form, you probably went to the Get Started page on my website, mansourlaw.com, and clicked on the trust administration and probate document checklist. So basically this one-page form talks about a few important things. So let's take a look. Before the first meeting, it's helpful if you gather any and all original wills or codicils. Now, a codicil is just an amendment to a will. So if a person made a subsequent document called a codicil, I would prefer if you bring all of those documents in. Now, if the estate plan was prepared by my office, we probably have those documents either in storage or scanned to our computers. So in many cases, if you are calling about somebody who was a client of our office, we already have this information, but you might want to check, especially if they went to another lawyer after they came to our office for some reason. Number two, I need all the original trust documents and any amendments that were prepared. And again, if it was our office, we probably would have those documents. The other thing that is very helpful for people to do is to basically try to take inventory of all the accounts that the individual had. The decedent likely had bank accounts, brokerage accounts, investment accounts, annuities, things of that nature. Credit union accounts, etc. And sometimes this is very easy to do. Sometimes the decedent kept very good records. They may have some records in their estate planning binder or a list of assets somewhere. In some cases, you may need to look at the mailbox and watch the mailbox for a couple of weeks and make sure that you are getting all the statements in the mail. Sometimes it takes even longer. I've had clients where 3 or 4 months later they discover a statement from an institution that they didn't even know about. So one of the things to do is to be vigilant about the mailbox and watch the mail and make sure that you keep a good eye on all the accounts and make sure you have a good list of them. That's one thing that you should do. Also, with respect to investments and stocks and things that go up in value, you may want to get something called a date of death appraisal. That means that you want to find out, well, it's not date of death appraisal, it's a date of death value. Because if you are going to be inheriting these assets, or someone else is going to be inheriting them, it is an important issue for tax purposes what they were worth on the date the person passed away. Because that becomes your new floor, or what's called a cost basis for the tax calculation. So the price of the investments when they were purchased long ago is no longer relevant. What is relevant is their date of death value. So for assets that grow, such as investment accounts, mutual funds, things like that, stocks, you want to get statements from the companies showing the value on the date of death. Also, it's important to order certified copies of the death certificate. This is usually done at the mortuary when the funeral arrangements are being made. They will ask you how many death certificates you want. If you're really sure that the decedent had a modest estate with only a handful of accounts, 10 death certificates are helpful. If you think that there could have been more, go ahead and order 15 death certificates. It's not terribly inexpensive, but it's also not very expensive either, and sometimes it's better to get them early on because it's sometimes difficult and time-consuming to obtain those death certificates at a subsequent time. Let's keep moving down the form here. The next thing that is very helpful is if you get a list of all the IRAs that the person had, individual retirement accounts, pension plan that they might have had through their previous employer. You might want to call them and ask about that. And it's important to find out on these kinds of assets who the beneficiaries were. Because keep in mind, even if the person had a living trust, some of the assets that the person has do not pass by the way of the living trust. They pass by way of a beneficiary. And the beneficiary is a person on the form that is filled out when these kinds of accounts are created. They basically ask you, who do you want your beneficiary to be? And you would list those people. So you want to make sure you inquire from the companies holding the IRAs and the companies handling the pension benefits whether or not there are any beneficiaries, and you might have to fill out a claim form and provide them with death certificates. The other thing that is helpful is if you have certificates of title for any automobiles. Now, the DMV has special procedures for automobiles. If they were not in the name of the trust, and most of the time they are not, there are other ways to get to those automobiles and other kinds of vehicles, but it's time consuming and it's never terribly fun, but it's helpful if you have title to those assets. Take a look and see if if the decedent had those documents in the glove compartment or elsewhere. Take a look and see if you can find any life insurance policies. Life insurance policies also pass by way of beneficiaries. So the decedent would have filled out a form when they got the policy, and that form would govern where their money goes. Same thing with annuity contracts. Annuities pass by way of beneficiary 99% of the time. So you might want to inquire from the companies holding the annuities and holding the life insurance about the beneficiaries. Now, they won't just tell you over the phone. They're going to have you fill out a claim form, provide a death certificate, in most cases a certified copy. Now, the difference between a certified copy of the death certificate and a regular copy is that the certified copy is actually a colorful copy that is certified by the county. It's stamped, it's all official. And a regular copy is just a regular photocopy of the death certificate. In some cases, you can get by with photocopies, and if you can, I would recommend that you do, because that will make sure that you don't lose all your death certificates and you have none left. Also, take a look and see if you can find the deeds to the real property, any real estate the decedent had. See if you can find the deeds to the real property. If our office handled the trust deeds, in other words, they put their real estate in the name of their trust, then we would probably have copies of those in our file somewhere. But if you have the deeds, or at the very least a list of all the real estate the decedent owned, that would be very helpful. Then it's also helpful if you get a most recent income tax return from the accountant or the CPA or whoever prepared the taxes, because those documents often have very up-to-date listings of all the assets of the decedent. So you try to make sure you don't miss anything. And then after you've taken a look at the assets, you're going to have to take a look at any bills or debts that the decedent had. So those would be credit card statements that you get in the mail. There might be some final hospital bills and doctor's bills, funeral expenses. You want to make a list of all those things. And I'll have a few comments about them in just a moment. Sometimes clients have stock certificates, bonds, deeds of trust, or promissory notes. In other words, people owed them money. There was some kind of contract and they were getting paid on it. Sometimes, especially some of my older clients, have original stock certificates from different companies. You want to make sure you look for those, and also any bonds, Series EE bonds or otherwise. Another thing that you want to keep in mind is whether the decedent had a safe deposit box in the bank, and they would keep their materials in there or any valuables in there. Sometimes that's a little bit tricky getting into those accounts. Now, I want to make a few general comments about what to do when somebody passes away. There is no emergency. You don't have to act right away with respect to everything. Sometimes, in my experience, clients start to panic and they start to do stuff and distribute assets and move money around. And what they sometimes do is they create more of a problem than they solve. I would recommend, of course, spending the first several weeks grieving for your loved one. Making sure that the funeral arrangements are taking place, etc. If bills need to be paid and there's not enough money available, liquid assets, you may have to pay out of your own pocket, or another family member could pay out of their own pocket, and they can be reimbursed. It is important to spend some time looking for date of death values for brokerage accounts, investments. Also, what you might want to do is, with respect to real estate, it is helpful to get an appraisal of the real estate. So you might want to call an appraiser and ask for what's called a date of death valuation or date of death appraisal for the real estate. The reason is that when it comes time to sell the real estate in the future, whether it's going to be immediately or several years down the line, that appraiser's report is going to serve as your cost basis for the real estate. In other words, it's not what the decedent has paid for the real estate many years ago, but the new cost basis or the new floor for tax purposes becomes the date of death value. And the reason you want the appraiser's report is because that's what you're going to use when the IRS wonders why you didn't pay any taxes or why you paid so little taxes. A quick example on this issue: let's say the real estate is worth $200,000 and your parent or whoever the decedent was bought it for $50,000. Well, when you sell it for $200,000 or $300,000 or whatever the case may be, you don't figure taxes on what the decedent had purchased the property for. That would be $50,000. You instead use the date of death value as your floor, and that's how you calculate the taxes. So if you sell the property for $200,000 and it was worth $200,000 on the date of death, that's a zero gain, and therefore no taxes will be due. And your appraisal report will be your defense if the IRS ever challenged that calculation. Because remember, you're trying to keep as much of the estate as possible for the beneficiaries, and you might be one of those people. So back to the original point, or one of the points I was making, which is there are no emergencies, there is no fire in the barn, as they say. The best thing to do is to talk to an attorney a couple of weeks after the decedent passes away. Gather all of the assets, make a very strong list of assets that pass by way of beneficiary, like IRAs and life insurance policies, and make a list of assets that don't pass by way of beneficiaries, such as bank accounts, investment accounts, real estate. In some cases, you might find that some of the accounts in question are owned jointly with other people. If the assets are owned jointly, then all there is to that is you present the death certificate, and that the asset goes to the remaining surviving people on the account. So if somebody had an account with their son gets the account. If they had an account with their sister gets the account. It may not be exactly what the family had in mind, but that's how it works. And then finally, you're going to end up with several assets that are just in the name of the decedent. Now, this is important. If the assets in the name of the decedent exceed a certain amount, you may have to go through the probate process. So, for example, real estate easily puts you over the limit in California, which is currently $150,000. So if you're over $150,000 and the assets don't pass any other way, you're going to likely have to go through the court system. Now, the $150,000 number is subject to change, so don't rely on this video. Make sure you check with your attorney regarding that. But that's the number currently in California. And if your assets are under $150,000 after you get rid of everything held jointly and everything that passes by way of beneficiary, and you're left with less than $150,000, there might be easier ways to get to those assets that you can discuss with your attorney that do not involve the court system. So in any event, I hope that this video helps you a little bit and gives you some plan of attack and some guidance. Of course, it's always a good idea to discuss things with an attorney and make sure that you're doing things properly. Remember, there are some procedures that do need to be followed. So make sure you check with an experienced lawyer before you start doing things on your own. This is Robert Mansour. I'm a wills and trust attorney in the Los Angeles area, and I want to thank you for taking the time to watch this video. I hope you found it helpful. Take care.